Sean, just like Sean. Privileged Sean. Here's Sean. Sean likes Aaron. Sean is on Team Toe. Sean was happy about that because Sean, giant piece of shit. Sean's like, that's Sean's breakfast. Sean's like, Sean, is Sean those big eyes? Sean hasn't read the statute. Sean hasn't read the statute. Sean is manufacturing reality. Sean is used to lying. Sean is making shit up. Sean's like, dumb. Sean's sitting there as a lawyer making fun of me.
Yes, I am making fun of you as a lawyer. As a lawyer, I'm making fun of you. Now, once again, if you had this, remember that guy who hasn't read talked about people reading the statutes, didn't read the statutes in Arizona. I mean, that was a FOD wide. And, honestly, when the guy's telling you, I've read the statutes, you could show us. Well, I read the case law. You could show us. We haven't seen that yet. Huh. It's like all those scientific studies. Where'd they go? I don't know. Don't know. Anyway, guys, welcome to Friday night. My name is Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland, Ohio area. Not for much longer. But for right now, I am. And tonight, we are talking about the saga of Alyssa Mercante suing SmashJT. Now, I still think her lawsuit's bullshit. I think it's ridiculous. And I hope... Who's messaging me? A family text. Or... Anyway, I think it's all nonsense. Alyssa's accused him in the lawsuit of defamation, of interfering in her business stuff, but also things like stochastic terrorism and, all a bunch of bullshit. And you're like, yeah, well, I thought it was a load of horse shit. And remember, JT went ahead and filed a motion to dismiss, and the judge kept the case on life support. It wasn't fully dismissed because Alyssa was given an opportunity to prove jurisdiction. Because at the point of the case when we left it last year, she hadn't established jurisdiction. The court even had the right to hear this case. And the court gave her opportunity to conduct limited discovery in regards to that. Well, that is where we kind of address all the stuff that happens tonight. And all the stuff that happens tonight is... Well, this is the result of that, and this is all turning into a dumpster fire. Is SmashJT's case over? No. Has he made it things harder and harder and harder and harder and harder and harder for him? Yes. Is he stepping on rakes? Yes. Or as I put it in the thumbnail, he is literally skipping through a minefield, a smile on his face, and kicking at whatever he sees poking out of the dirt. And it's not working. But let's get to that. When we left off, there were some kerfuffles about motions to compel and whether things were being properly done and done in a timely manner. Remember, chat, when it comes to lawsuits, the rules of civil procedure, the rules will make you or break you. If you follow the rules, if your case is toast, you're toast. But for the most part, if you follow the rules, things go a lot easier. But that's where we left off. And at that point, Alyssa Mercante's team was asking for sanctions. And from here, things have escalated to TLDR. Yes, JT is getting sanctioned for discovery violations. So it's, we're going to get through all of this. So here we go, chat. Where do we start off? Well, we ended this case, we ended up following it right at the end of February. We're going to skip through some parts here. I'm not addressing every filing Some of these filings we're just going to breeze through because not all of them are important. And there's only parts of them that are important. But ultimately, when we're looking at this here, there was an order for sanctions. And what did the court say? Well, the court started out by saying, we're going to deny the motion. This is February 26th, end of the year, or end of the month. I'm denying the motion for sanctions. In evaluating whether to impose Rule 37 sanctions, the court must consider the willfulness of the non-compliant party. 2, the efficacy of lesser sanctions, the duration of the period of non-compliance, and 4, whether the non-compliant party had been warned of the consequences. And they point out, and this is the judge saying, both parties acknowledge discovery was ongoing and only several days late. Plaintiff filed motion for sanctions on the 19th, just 2 days after the deadline. And the judge is like, you guys need to fucking slow your roll. She's not saying they were wrong. It's just stating you guys need to slow your roll. Not right now. Not right now. So we move on, and there is a flurry of filings. And guys, some of these are things that were put under seal. So there's going to be doubles of things that get sealed and then they're unsealed and things that have happened. But we're going to start out. With some of this stuff here. So let's start out with on March 5th. This is a letter from Ron Coleman and the Ron Coleman. Actually, I forgot. Sorry, Alyssa. Sorry, JT. Sorry, Ron Coleman. Sorry, J. Remy Green. Sorry, all of you. I got something to say. I got a package in the mail. And it didn't show up right away when I checked in my P.O. box, but it did. And we have something to talk about today. And this is from somebody ordered shit from Mad at the Internet out of Salt Lake City. So we're going to take a look at this real quick. And, we're going to take a look here and see what this is. So it's very thin. So let's see what this is. Okay. So, okay. So real quick, we're going to switch to camera views here. We got a mail call we're going to do real quick. All right, chat. So we got a packing slip, and it's no notes. I don't know who this came from. So whoever did this, thank you. I don't know anything about you or whoever did it. Is that what I think it is? So these are all meme Met at the Internet badges. Exceptional individual. Let's see if I can figure out which ones are which here. This is a skull. A kiwi bird skull. We have Docs Found, which is a play on Foxhound from Metal Gear Solid. The Kiwi Farms and I think this is the Sauron, because I've seen these before. These are hilarious. We got another exceptional individual. I'm going to have to put these on my briefcase. We got the Lolcow Award. We have Kiwi Ops. These are pretty funny. This one is just the farms. Kiwi on there. Inside of a kiwi. Another cow. Another Docs Found, those are hilarious. Another Sauron. So whoever got these, thank you. These are awesome. Docs Found, you deserve that one, yeah. Please be patient. I have autism. Very true. Another Kiwi Ops. Archive everything. Always a good thing, chat. Always keep your receipts on everything. And, that's one of the things people get mad about on the farms. The farms is very good at archiving. That's usually the thing that pisses people off. All your dumb shit gets archived. And that's why most people cry about the farms. Another I have autism. Another archive everything. Another kiwi. And another kiwi skull. These are pretty cool. Thank you to whoever got these for me. I am going to have to figure out what I'm going to do with these. I can wear that one on your suit for court. Yes. That's great. So thank you so much. I'm going to have to figure out what to do. And then chat, there is the address. This is not going to be the address for long to send stuff to, but for right now, it still is. So, can I get those sewed onto my suit? I bet I could. I'm not going to. Oh, anyway, there we go. That was, wanted to address that. So thank you. Whoever got that for me, thank you so very much. But now it's time to get on to the main event. I need a lapel pin. Yeah, that would be funny. That would be funny. All right, let's get back to this. So this is Ron Coleman. This is from the 5th. Now, remember, we were just in the issue of we were going to have sanctions. What are we going to do? What's going to happen here? All right, well, let's see. So they cite their, remember, chat, everything's done by a letter in the East Coast. That's a traditional way of filing motions, is through letters. It's not common in other places. That's just how they do it. So you may not like this, but it is what it is. I will say Ron Coleman gets points for, justified alignment. J. Remy Green, you're not doing justified alignment. That makes me want to have a stroke. But anyways, here we go. They point out that they want to justify the continued sealing of Exhibits 1 through 4 that were filed under seal previously. So a bunch of things were filed under seal. And they want to point out what they want to do here. And they point out this case is at the jurisdictional discovery stage. No merits discovery, meaning discovery on the actual claims. So the defamation, the stochastic terrorism, the tortious interference. None of that has been done discovery-wise. They point out the exhibits at issue were produced in response to the jurisdictional discovery and were submitted to the plaintiff's attachments. They have not been submitted in connection with any dispositive motion. The court has not relied upon them. So they're asking for it to be kept out of the way. And they're asking for it to be kept sealed. So what happened here? And here's where things make you want to start fucking smacking your head. Exhibits 1 and 4. ChatGPT conversations reflecting litigation strategy and client-to-counsel communication preparation. Now, chat, we went through this. We talked about this with that case, US v. Hepner, and we talked about how the idea of using AI, you have no protections because everything you put in there is accessible to a third party. So you lose attorney-client privilege. Also, more importantly, your attorney has not told you to do it. But also, it's not work product. So it's just a complete disaster to do this. Don't use AI for that. I don't care if you're an attorney and you're using Protégé off LexisNexis or co-counsel from Westlaw. I've got a discovery demand out right now in a prosecutor's office where I'm pretty sure they put a bunch of shit into ChatGPT or Claude. And right now, they've kind of shit a brick because I demanded any of that information. And we're probably going to have a hearing on it. And I don't know if I'm going to get to have that hearing before I have to withdraw. But it's going to be kind of interesting. It's going to be an interesting case. ChatGPT, Grok, OpenAI, whatever it is you think you've got, don't use them for your legal documents. But here's what JT did. The defendant used ChatGPT to analyze a settlement proposal communicated by opposing counsel to defendant's counsel and to formulate defendant's response to his own attorney regarding that proposal. Specifically, the defendant submitted the text of opposing counsel's settlement to ChatGPT and asked for an assessment of its legal and strategic implications. He then asked ChatGPT to draft a brief communication for him to his attorney, conveying his position that he did not wish to concede jurisdiction or trade away leverage. You could just say, Ron, I don't want to give away jurisdiction or trade away leverage. You don't speak to your attorney if you think, I need to use. No, we don't use the faggoty legal terms when you're speaking to your attorney. Tell him what you want. That's the easiest thing in the world. I don't need you to give me the magic words. Are we going to agree to their terms or not? Yes or no? Okay. No. What do you want to do from there? Do you want to keep fighting jurisdiction? Yes. Boom. You don't need to do anything else for this. You don't need to do anything else for this. Yes, and it literally, yes, I agree. Luke is right. Just say no. No. 9 yet. You don't have to, like, you're not writing fucking Chaucer. Work product protection. These are not work product. These are not documents prepared in anticipation of litigation by or for a party. I don't agree with this at all. You guys remember we talked about that court case where the guy went and used Claude, and the court said that the FBI and the DOJ can read those documents. I fully agree with them. This is not work product. It's work product that a third party has had access to. And this is where I 100%. J-Rock says, who did the AI? The client. Ron has not used AI. This is all the client. This is all SmashJT. So this is all SmashJT using AI. Basically, anytime SmashJT's receives something, he gives it the chat GPT and says, explain it to me like I'm 5. And that's going to be a problem here we're going to see more and more of. Luke is saying Ron has also used AI. I don't think that's been clearly established. But and I'm going to leave that alone for now. I don't think that's been clearly established in a way. He says there's no serious question these conversations meet the standard. They no. Ron, you are an intelligent man, but there is no way in hell they do. Yes, he was engaged in litigation, had received a proposal, and used it to understand the proposal and to formulate a response to counsel. And this was all done through a third party. It's not work product anymore. The fact the automated language model, rather than a human advisor, served as the interlocutor does not change the activity. No, that's exactly the same thing. A human advisor, like if you went and asked your buddy, hey, man, what's this say? That's no longer privileged communications. Anything discussed with his buddy would be discoverable. Anything would be discoverable from his buddy. The defendant was processing litigation strategy and preparing to communicate a litigation position to his attorney. That is at the core of what work product doctrine protects. I mean, it would, but not when you're doing it to a third party. What about other advisors? Unless it's part of your legal team, that's not going to cut it. Unless it's part of your legal team, that's going to be discoverable, in my opinion. They say plaintiff's letter characterizes one of these conversations as manipulating prompts to generate a desired answer. That's literally what you do on ChatGPT. And we're going to see what SmashJT did. The characterization is not accurate. In Exhibit 2, JT asked a question about the Wix platform access and received an answer that gave multiple meanings to his question. Then he clarified which one he meant. The defendant does not concede that any characterization of impropriety attaches to his use of AI tools during the pendency of litigation. And that's the thing here. Using AI in itself is not wrong. It's wrong when you cause problems in your case and you miscite things or there's things improperly done. If you went and used AI, if you went on to Claude and I went and I was working on an appeal and I asked Claude I fed him the transcript and said, hey, generate me an appeal that'll win. And they spit one out and I could cite check all the things. I check all the citations and it's 100% on the money. It's not wrong for me to submit that to the court. That would not be wrong. When you use AI is when it turns into a dumpster fire and it doesn't go right. Using AI in itself is not prohibited. No. But we also learn, though, the problem is with ChatGPT, we talked about the case where the guy killed his mom. These things are meant to be supportive and suggestive and like, you go, queen. Jensen posts with an AI query about UCAN as work product. No, because that query is also accessible to third parties. It's accessible as part of the large language model. They can use all that information to build and build and build upon things. So no, it's like you submit a note to a librarian and ask him to pull stuff out for you. That is not acceptable like that. That doesn't work. It doesn't work. Now, somebody asked a question here. And yeah, ultimately, here's the problem. The problem is these guys fucked up in discovery and gave away all kinds of shit. And we're going to get to that because that's a whole... The problems are building, chat. We're starting out where like, oh, this doesn't seem too bad. But don't worry. The oh shit is going to go... It's like an F-15 taking off like to go launch an ASAT, an anti-satellite missile. It's just... Whoa! Right up. The oh shit meter is going to go off the charts, chat. So they say plaintiff's letter suggests the defendant waived privilege by disclosing the communications to ChatGPT and third parties. Yes. And they're in the Eastern District of New York. That case we covered was in the Southern District of New York. Guys, that case we talked about is like making its way through the legal world. It's a big fucking deal. He says the arguments don't apply. The communication defendant submitted to ChatGPT was opposing counsel's settlement proposal. Not a privileged communication from defendant's counsel to defendant. No, part of that was a privileged communication where he says, I want to prepare a response to Ron. That's normally when your client speaks to you, that's a privileged communication. I had a client today send me a text. That's a privileged communication. If I let other people see it, it's not privileged anymore. If I told people about it, it's not privileged anymore. And they say opposing counsel's communications to adversary counsel are not privileged. That's correct. And their transmission to a third party carries no privilege consequences. The effort to formulate a response to his own attorney, yes, Ron, this is where you're wrong. It is a disclosure of privileged communications. They do say, and this is the smart thing here, we reserve all rights with respect to the broader waiver arguments the plaintiff has raised. They talk about the ChatGPT conversations regarding the discovery order. He asked ChatGPT for a plain English explanation. The fact that he used an AI tool rather than calling his attorney for an explanation does not strip the activity of its character's preparation and litigation. It does. It 100% does. The document does not reveal any attorney communications. Okay, well then it's accessible. He's saying it warrants protection as work product. Guys, remember, work product is stuff that you prepare in preparation for litigation. So if I write a memo to my client and say, here's what our plan is, that's work product. If I'm doing research and I have a draft prepared of something and I change my mind, that's all work product. Luke is actually, I can waive the, I can go through the privilege of, it's waived in the sense that it no longer exists. It's been breached. It's been killed, because there are times where attorneys do have the right to do it. But yes, in general, if I let a third party do it, it's a breach. But there's the concept of waiver has happened. Not the technical I'm waiving and allowing you to do it, but it's the idea of waiver. As talking here, the broader waiver argument is more of what I'm arguing there. And it says the conversations regarding Wix and the platform capabilities. He asked about the technical capabilities of the Wix website platform. And they go through here, and that said that, JT submits sealing is warranted on 2 grounds. The conversations occurred during jurisdictional discovery and in direct connection with the effort to understand what technical records he could access and produce. The context is litigation driven. No, it's not. No, it's not. And secondly, the presumption is minimal for discovery materials not used in judicial determinations. It's still not going to work. It's still not going to work. And then they say, finally, the DM exhibit. The remaining exhibits are excerpts of JT's direct DMs that were produced. They're communications between JT and third parties who are not parties to this litigation. It's like, yeah, that got turned over too, guys. That got turned over too, chat. That got turned over too. That got turned over too. And they say, finally, the defendant notes that if the court determines jurisdiction is absent, which remains a live question, it is. We don't know yet. These materials will never bear on the merits of the action. Unsealing them now would expose private communications of non-parties in the case that may never proceed to the merits. That is not what the law requires. I agree. That makes sense. But ultimately, the rest of this here, you know, we want to keep it all sealed. I'm like, nope, 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 nope. 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 Nope, nope, nope. The next thing that came out, the next thing that got filed the next day was a status report by Ron Coleman. He goes through and talks about more things here. They talked about, you know, what they need to do here. There was a joint status letter, proposed edits went through. They point out there, you know, the defendant produced the complete corpus, the complete body of his Twitter DMs and text messages chat. So if you have conversation with JT, you know, that was just kind of turned over en masse. So they were re-exported to include full user identity information and embedded graphic assets that were absent. These include the hypnotic conversation thread referenced. Also, a reasonable search of 2 alternative accounts, his other JT accounts, and they determined these contain no direct messages. So, you know, the Give, Send, Go donor data, including emails. If you send anything for Give, Send, Go, they have your information now. And now that was going to, it's not, I'm not saying they wrongfully gave that. They would have had to have. But yeah, that's all, you know, remember, the psychopaths on the left will use this to harass and intimidate you. So remember, guys, when you jump in this, you better understand you're playing with your, you better make sure you got your fucking spurs on, because these guys play for keeps. And remember, you're dealing with Bolsheviks. And there's only one thing to do with them. This addresses the specific deficiency the courts noted regarding the Give, Send, Goes. The ChatGPT conversation logs. The complete export of his ChatGPT conversation. The Discord member spreadsheet. You know, they talk about emails. They went through his emails. And they reviewed both accounts. There's no emails there. They use Discord primarily to promote videos. They talk about Discord DMs, the text messages, Instagrams, and other DMs, and other AI tools. They claim they haven't used the rest. They talk about the super chat donation tracking records. A moderator. Now this is something I don't know why they're doing this, because you can track all of this on, you know, like, this is all unnecessary. Like, why do you make all these layers of stuff? You know, regarding super chat donor tiers, I've showed you guys what's in the super chats. Like, I don't have a whole lot of access to things, but he created more records, and I don't understand why you would in this world where you're engaging in the Kulturkampf and you're being a fighter in the culture war. Why would you mass more documents and discoverable material? This literally doesn't make sense to me. You know, the defendant's preparing a privilege log, which they kind of fucked up, and we're going to get to that. We're going to get to a lot of problems here, chat. The defendant disputes the contention that attorney-client privilege has been waived and reserves all rights with respect to that issue. I don't know about everything. There are other outstanding disputes, and they want to come back in a couple days to deal with stuff. Well, there's some issues here. When we get on to, you know, here's Alyssa's attorney, J. Remy Green. Once again, I will say they did a phenomenal job. Like I said, by the end of this, you're going to understand why I will end up saying well played, because they do a very good job here. They point out the defense made a production late night early this morning. A bunch of things that come out, you know, they're like, all right, we're working on discovery. Now, this is another thing from J. Remy Green. Remember, we could tell the difference of who's doing what by the color of things here. Now, they're opposing the confidentiality and protection of things here. And why do they do that? Because these are blanket things that are being asked for. And you're allowed to oppose. You know, just like when that motion to compel came in, Ron Coleman and JT could have opposed and fought that, but they didn't, so they kind of got screwed on it in the way they objected, using boilerplate bullshit. Well, now we're dealing with some more things here. They talk about that the court's individual practice rules. Remember, guys, every court, you have the Eastern District of New York where this is happening, has their rules. You have the rules of civil procedure. And then you have for each judge in that courthouse has their own rules. These rules make or break you. The rules will break you if you don't stay on top of them. But anyways, JT's blanket designation of certain materials is confidential. Plaintiff makes this motion as she looks ahead towards how to amend the complaint to incorporate jurisdictional discovery material. And that's a problem. If everything's being declared confidential, how do I use it? Now, they point out that first, the entire February 19th production was marked that way. All of the ChatGPT logs have been marked confidential. And they point out that there's a lot of questions here. The plaintiffs, they asked JT to confer on the blanket designation of all documents as confidential. You can't just do that. Like, not everything is confidential. You can't just do that. It doesn't work that way. There's no indication any of this information fits into the categories in that would qualify as confidential. A blanket designation is consistent with parts of what's going on. They're pointing out, like, you can't just do that. It doesn't work. Well, they point out they're saying Ron Coleman never responded. Like, all right, well, that's good. They said thereafter there's issues. They said before defendant cut things off and sent a solo letter, plaintiff included as an issue confidentiality. They asked to meet and confer. And remember, guys, just like Russell Greer, you meet and confer. They say we asked to meet and confer over the bulk designation of records as confidential in violation of the confidentiality order. They say there's no indication any of this is consistent. And it's flatly inconsistent with parts of this paragraph. And if we make a motion, it's your burden to explain the designation. And that's true. Because Rod and JT have to explain, why does it all have to be confidential? You have to go through that. They point out when the defendant responded on other issues, they asked to confer on this. And they say, please think of this. Please take this as the last request for availability, confer on the confidentiality. And here's the thing, and it says, this is the attorney once again speaking. To be clear, I think the revised DM production was not designated, but the whole ChatGPT production was, which we will move on. Meaning they're going to file a motion for that. And still another email. All of what I said in my earlier email remains outstanding. Given a failure to address or meet and confer, we will make a motion to redesignated short order, which is how you do this. This is how you properly handle things. I asked you, you have not responded. I will therefore file a motion. That sometimes like, oh my God, wait. But this is properly done. Defendant has still not responded at all. They're just saying, Judge, look, I did everything I could, because the judge might say, are you sure? Did you try? Did you really try? Well, but they talk about under the protective orders, and there already was a protective order here, challenging confidentiality. The party that designates stuff as confidential bears a burden of proving it was properly designated. And they point out that the parties must attempt to resolve the issue in good faith. If they cannot, the burden on a motion is the party designated the documents to demonstrate the basis for the designation. We're kind of cutting through this, chat, but this is the basic information here. When you say no, nobody's allowed to have that. We can't talk about it. You have to explain why you can't. Nobody can talk about it. Nobody can put it in a motion. They say as far as the burden is what's set here, a party seeking to maintain it must show good cause for the designation with a protective order. And it says using mandatory shall provides only 7 categories for proper designation. Things like financial and tax data, medical records, non-public criminal history, and other very sensitive matters. Yeah, that's why it's confidential, because I'm going to look like a fucking retard. That's not an answer. Sorry, you have to suffer. Are we getting are you saying that because we did, or are you just like asking? Like, if it's happened, don't be coy, just tell me. Then yes, we'll cut to that. I just don't know if that means. And they say, moreover, the limitations forbid blanket designation because, yes, not everything can be that confidential. It's like when you see the government and they just black out page after page after page after page after page after page. You can't do that. You can't just do that. Like, that's not fair. That's not right. And they say that JT can't meet his burden of proving it. Because of the refusal to confer, plaintiff's at a disadvantage in opening this briefing because he doesn't have any indication of why the defendant believes his designation is appropriate. However, it seems reasonable the argument here would track his argument in the pending sealing motions. And they say these arguments are basically ChatGPT transcripts. They made no reference to the kind of documents that's allowed, and they say that the defendant was processing litigation strategy and preparing to communicate litigation to his attorney. And that's Ron Coleman's own words. It's Ron Coleman's own words there. So that's why this is, chat, this is just not, this is not what you do. This is not, honestly, this is not going very well. This is starting to kind of, we're starting to see things start to kind of come off the tracks. The wings have not fallen off the airplane yet, but Zirdi's saying there was an EAM. We did an EAM. Ooh, like Sky King, do not answer, do not answer. Like that kind of like emergency action message, like like Nuke Flash Pinnacle mainsail, like all that. Uh-oh, that's not good. That's not good. Ploxerd, I'm not talking about Sky King like the pilot. If you've ever listened to the emergency action messages, like whatever call sign, that'll be like Sky King, do not answer, and they'll run off a code. What's an EAM? It's an emergency action message, generally regarding the authorization and release of nuclear weapons. So if you've ever seen, yes, your country's only military feat is sinking boats in Samoa. So if you've ever seen Crimson Tide, that message coming in is an EAM. Or if you go on YouTube right now, you can Google EAMs that have been recorded. And they're kind of like, some of them are for operational things. A lot of them are drills. But sometimes they are forced posturings that like, we're going to DEFCON 2. And that EAM goes out. So, oh, there's a tweet out there. Oh, Jesus. All right, well, we'll take a look at that. Maybe at the end here. So, but yes, this is the argument here that I agree with. Work product does not, getting back to this, work product does not exist for documents disclosed to an adversary. Yep. If you've accidentally disclosed a privileged document, it waives the privilege. And you can't seek to keep it confidential. Womp, womp, womp. You waive work product protection by taking actions inconsistent with the purpose, like disclosing products to the adversary. Yeah. So it's clear. It's clear. There is no non-frivolous claim that ChatGPT logs have any privilege to the extent they ever did. And I agree. There's no non-frivolous argument for that. The AI chatbot logs are not privileged without facts not present here. And that's another thing. There's another threshold issue. The chat logs in an LLM are not privileged. It cannot be work product to begin with, at least unless an attorney directed you to the chat bot, but nobody's claimed that here. And we go through this here. We get to United States v. Hepner. And you know what? This is what effective litigation strategy is. You take that case and you run with it. You take that case and you run with it. And that is true. And once again, this is proper lawyering here. The blanket designations are forbidden. Yeah, I agree. You can't just do that. You can't just do that. The defendant must clearly identify protected portions. You have to. And otherwise only designate specific pages. You can't just say the whole thing. You can't, JT can't meet his burden to show good cause. It says the court should grant Rule 37 cost. As with past motions, plaintiff Alyssa is entitled to her mandatory fees. There's no reasonable argument for defendant's choice to designate these documents confidential. Plaintiff notes the court has reserved the Rule 37 issues until the formal close of jurisdictional discovery. And they make the point this is to preserve the right to seek fees with the rest of the Rule 37 fees. But with that said, they, and this is, we're getting to Russell Greer territory, the continued recalcitrance plaguing discovery may be alleviated if the court makes a limited interim award. Yes, their argument is, Judge, they're fucking around, and if you come in and just, that might get their attention and correct it. Chitin, it says, what is in these chat log that she wants? They believe it discusses trial strategy, and he will incriminate himself, which he does have statements which, inculpate himself a little bit. So that's the problem. But more importantly, they want to find out what's in there. So once again, chat, this is proper lawyering. Proper lawyering. As this goes on here, as it goes on here, chat, we have to go through things, and some things starts heating up, chat. Things start heating up. And Luke has been spoiling the story here as I'm trying to tell the story, as, it's like one of those Trump election night, clip reels. Dun 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 dun. We're at the point where it's like dun 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 dun. It's starting to speed up here, chat. We're starting to speed up right now. And this letter is another thing of that speeding up. This previous one was on March 11th. Now this is March 17th, St. Patrick's Day. And we are starting to speed up, guys. You triggered my autism, okay? It's too funny to hold in. Well, so anyway, this is, once again, J. Remy Green. As the court recalls, my firm and co-counsel represent the plaintiffs. And they talk about the, irate regarding the motion to remove the blanket designation as confidential. As explained below, defendant failed to file in any opposition to the motion and express he does not intend to file a direct opposition. Accordingly, it should be granted. Yes, if you won't oppose, it gets granted. Under the court rules, if you don't file any opposition, though, yes, they basically filed the motion to seal, it should be removed. They point out, though, this is not the first time they missed a deadline to file a motion to oppose without explanation. If in cases like this, you should say, Your Honor, we're declining to file anything. Because otherwise the court's going to have to wait open till deadlines, and courts don't always like that. He says, I asked the defense counsel if he plowed to play any motions. He initially said, how is your motion to de-designate different from the motion to seal? Aren't these the same issues? Then when I asked if he intended to file an opposition, he said, no, my intention was that our motion to seal would be considered an opposition, which is why we included the list of relevant prior filings. And this is where they're making an argument of, if defendant means it seriously, it raises a grave candor issue to the court. And this I think is, I will also say, J, I don't know, I don't know what the J stands for now, but whatever it is, J, I'm just going to call you J. Justified alignment, please. Justified alignment, please, for the love of God. Especially down here in a footnote. Justified, please. On one hand, if defendant was simply refiling his motion, it could also be an opposition filed at a later time. In this case, the motion is unopposed, but there is no candor issue. On the other, if the defendant was making a change to his motion to make it address a motion filed a week later, the content of the letter violates Rule 11. As noted, the defendant uses a fabricated quote in his motion. Not for the first time. We're going to, like I said, I was kind of holding off on that because it's, there's some arguments to this. And it, I should, and, goes on. I should also note this explanation is inconsistent with what's going on. And why he failed to file. Yes, the clerk called me and asked me to refile it as a motion. Now the world should be at peace. When I asked if that call to the clerk said plaintiff should refile their opposition, the defendant said no, and I did cross-refer to your submissions. So they said, and the new letter remains dated March 5th, so it is unclear how it could oppose a motion filed on March 11th. Yeah, but that's really not the big thing here. That's not the big issue. Here's the problem. At any rate, the motions contemplated the protective order are different than a motion to seal. And they talk about the 4 documents defendants seeking to seal are not the same as the thousands of documents designated confidential. Those at least have some connection to counsel. And they're pointing out, you want to seal some documents, but not all of them. Like, you know, you're only addressing those, but what about the rest of them? And this is where you start getting fucked. Perhaps most clearly, the plaintiff explained in the motion, the vast majority of what was produced has nothing to do with communication with counsel, unlike the examples filed previously, which plaintiff filed on the motion because they had content in order to make arguments that she wanted to make about sanctions. So regardless of the result, even if the court were to say documents disclosed to an adversary can retain work product protection, and the chat GPT logs get that protection at all, the designation of least those documents should be removed. Yes. The most you can have says Smash believes that he wants his info to dox and harass, not for legal legitimate purposes. I'm not sure anything can be done about it. There's nothing you could do. And is it going to be about harassing? It's kind of like Ethan Klein. Yeah, Ethan Klein's using the copyright case to like do this stuff, but in reality, he wants to make these people suffer. He's going to be Lex Luthor. He's going to be that evil son of a bitch. He's going to crush them. Yes. Yes, he is. He's using the legal means to make it happen. Alyssa Mercante and them are doing the same thing. We're going to take this information and use it. But they're doing it under the cover of a legitimate court action. So yes, there's nothing you could do. And guys, you know, you guys may not think you are in the Kulturkampf. You are. You are in the culture war. You know, for example, J. Remy Green joined my Discord. I don't know if he's still there, but he did. And people are like, oh my God. I'm like, what? What did you expect? Like, searching around for information. Like, the internet is not secret. Like, there are no secret places for you to go. Like, yes, you're basically just meeting out on a street corner, hanging out. Don't, you know, you got to think about it that way. Remember, don't say anything on the internet you're not willing to see in a court filing or in a deposition. It's really critical. Now, here we go. Presumably, the defendant reviewed the opposition to his motion, and this is going back to here. We need to address this, what's going on here, and readopted the fake quote after he received notice constitutes exactly the sort of thing courts have imposed grave consequences for. And it's not the first time defendant has, after notice, continued to try to get the court to adopt fake quotations that are not from the source he says they're from. Yes, misciting a chatbot log as or an official statement by Google is frivolous. Yeah, so it sounds like there's some shit going on here, chat. Sounds like somebody's playing around with AI a little bit. And they say, here's a timeline around if the court decides the proper content of the letter. On March 5th, defendant filed number 61 using a fake quote. On March 6th, pointing out the quote was fake. On March 11th, plaintiff filed another thing saying after the meet and confer, seeking to remove plaintiff confidentiality. On March 16th, defendant cited the same fake quote despite notice. So once again, as noted, defendant's motion sought to persuade the court using legal authority that does not exist because it used a fabricated quotation from a real case. And if the defendant really did mean to submit the refiled motion as a new opposition, he necessarily knowingly tried to convince the court to use a fake quotation in deciding issues in his motion. And that's why the Rule 11 thing popped up. And you're like, wait, how does it be Rule 11 just by refiling? Because if you've been told it doesn't work, you can't turn around and use it again. Now it's knowingly doing it. So it sounds like somebody's using AI. Whether they're using Protege or co-counsel, it's just not working. And Chitin saying, yeah, AI will fake stuff, but the problem is, and I tried this once before. I tried using ChatGPT on something. I said, tell me about X in regards to oil and gas here in Ohio. I already knew the answer to the case. I was kind of curious to see what would happen. And ChatGPT starts going through it, and I said, that's not right. The case you give is not correct. And it says, oh, yeah, you're right. I'm sorry. My bad. And it's like, let me fix that. And it gave me one that was still, I'm like, still wrong. Still wrong. Still wrong. It goes, oops, sorry. I'll fix that. And it's still wrong. And I just said, you made this all up. There's none of that doesn't exist. You're like, you're right. I did. And I don't have an answer for you. Like, you can't trust fucking AI. You cannot trust AI. And it just doesn't work. And the defendant fails to engage with black letter law if the party voluntarily discloses documents and waives that privilege. They say, yet, of course, the motion to seal does not discuss anything at all or the other decisions of blanket designation or disclosure of work product. Nor does he discuss his total failure to meet and confer. And they say the lack of care on this docket is hard to figure out how to address. Earlier, the plaintiff asked for a conference because of just how hard to understand defendant's conduct was. And the court expressed at that conference that its overall sense is the defendant is not meeting his obligations. And that's the one, Chad, if we go back to where I got owned on it, Ron lost his shit, it sounds like. Yeah. And they say perhaps at this stage, another conference would be in order. And you might say, oh, this is all snarky. I'm genuinely at a loss for what to do here. I mean, at some point, that's what you're just saying, Judge, I don't know what the fuck to do. And they say at any rate, nothing in number 66 is in opposition to 65. And they just point out here, they should be a show cause and direct the defendant to explain how he came to make fake citations. And yeah, they're just, once again, this is competent lawyering by J. Remy Green. Now, Ron Coleman comes back, immediately answers back with all this, but that's not true. A day later. And he says, look, Judge, you've already handled all of this. You've already handled all this. We're not going through it again. We're not dealing with this. He says the missed deadline is inaccurate. And we're not getting through this here. The substance of the filing was not altered. The cross-references and submissions were expressly included. And the documents on their face were the same 4 exhibits that are both the subject of the underlying dispute and the redesignated motions. Because they had to send stuff in, the court said redoing it. Yes, J. Remy is earning his green. Yes. Actually, true. But we get to the big part here, the fabricated code allegations. They argue at length the defendant's citation to Hickman v. Taylor for the phrase prepared in anticipation of litigation is fabricated. They're saying that's not true. Prepared in anticipation of litigation is a universal judicial shorthand for the Hickman work product doctrine. He's saying it appears in every circuit's formulation of the standard, including the Second Circuit's own statement in the United States versus Aldman, a case plaintiff herself cited in these proceedings, which ask whether a document can fairly be said to have been prepared because of the prospect of litigation. And they say the court's own order yesterday cited matrix essentials for the work product waiver proposition in legal context where Hickman's foundational. And he says the absence of a pin cite is a citation form issue, not a fabrication and characterization. It as one. Saying like, you're telling me I'm abusing the system and being wrong. Well, that itself is a misuse of candor. So he's like, it's not me, it is you who have a lack of candor. By accusing me, you yourself have a lack of candor. The defendant's mindful courts have expressed concern about LLM citations to non-existent cases. This is not that. The proposition cited is black letter law. The case cited is real and says what every lawyer understands it to say. That's a little bit of a I don't like that. I don't like that here. The other side does not cite cases without reading them himself. Plaintiff's conflation with a missing pin cite is precisely the kind of inflammatory overstatement that has characterized her approach throughout the litigation. He's saying, this is the shit she's doing, Judge. Being fucking ridiculous. Okay. Now he comes on to talk about the meet and confers. this is the thing here. This is not the first time counsel has threatened to report counsel statements, including statements made in the ordinary give and take of a discovery dispute, to the court. Well, yeah, if you say things that are improper, you can be sanctioned for your conduct in a meet and confer. Like, that's not immune. That's not stuff that's beyond the court's jurisdiction. Plaintiff's counsel's own summary email of today's conference, transmitted the same afternoon this letter was filed, illustrates the dynamic precisely. Counsel explicitly notes that defense counsel's statements during the call are recorded in Catherine in my notes verbatim. A formulation that serves, and this is where Catherine is, she's part of the Cucks team. She's like, I'm OSINT. Yes, you can fucking Google. Good job. But he says this is a formulation that serves no good purpose in a good faith discovery summary, other than saying that those statements are being preserved for judicial use. Ron, what? Yes! Anything you say can and will be used against you. If you're saying stuff that's improper, they're going to hold you to it. They are going to document and record. Like, what are you bitching about? What are you bitching about here? Like, really? Yes. 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 We're writing down everything so we can fucking hang you with your own words. Judge, no! It's like, yes. Duh. Or you can take that email and, like anything that's out there, especially if there's email conversations, print as a PDF and attach to your motion. Your Honor, here's what counsel said to me when they called me a cocksucker. I don't understand the point, dude. I don't understand it, Ron. Like, yes. And if you thought these people were acting like snakes in the grass, you can't sit there and cry about it. They're not breaking the rules. So deal with them like if they're the sneaky Bolsheviks, then fucking crush them. You're fucking Ron Coleman, the warrior of the culture war. The field marshal of it. Successfully out there waging battle. Then wage your fucking battle. Wage your battle and crush the enemy. Can't be crying about it. Defendant raises not to seek relief, but because the court's observations at the February 9th conference that the parties need to engage in good faith meet and confers is difficult to square with the process, and one party treats counsel as a discovery call as an evidentiary proceeding against opposing counsel. Well, if they think you're lying to them, they're going to fucking document it. Yeah. Counsel should be able to engage in these conferences with candor and in a collegial manner. I think you mean manner. Plaintiff's practice of cataloging gotchas makes this impossible and naturally affects the progress of any matters in dispute. Then know you're in that. Once again, you're in a minefield now. That you can't complain. You're stuck in the minefield. You have to walk out of the minefield. So what do? You walk down the cleared path. You don't go, I'm going to go over here and fucking kick this thing. It looks like a rock. Boom. Oh, it's a mine. No. Stick on the path that's been marked and just get out of it. I don't know why. I don't know. The defendant will engage in meet and confer in good faith as he throughout this case and ask the court to be aware of this dynamic if the parties can't reach an agreement. It's fucking belly aching for no reason, man. Like, what are you doing here, bro? What are you doing? I don't get it, man. Yes, I acted like an asshole and they're documenting it, Judge. It's like, no. It's like, what happens? So right after that, March 17th, like that day, which this kind of tells me this was pre-planned, like they expected this to happen, because J. Remy Green goes on and says, is ready to go with this. This is probably sitting on strip alert. And I've never been in this position before where I was able to just be like, I knew this was going to happen. And went, boop. But it happened, yes. Aktong Minen. Yes. Aktong Minen. They say thematically, the defendant keeps suggesting plaintiff is raising the failure to do basic things like file an opposition or respond to request for tactical advantage. She is not. Well, he is not. In fact, on substance, counsel's lack of attention to details immeasurably benefited our client. He has turned over in jurisdictional discovery documents that conclusively demonstrate actual malice. Yes. The issue is counsel's behavior, the refusal to provide discovery, the blown debt, and this is an entire fucking thing here. This is the entire fucking footnote. The deadlines or refusal to engage in meaningful meet and confers is all prejudicing parties by dragging this proceeding out immeasurably. And that's a particular concern because we know from the ChatGPT logs, counsel produced to us without reviewing any of them. Yes, Chad, he turned over discovery without looking at it. And how do they know that? They were produced. There's a they. Once again, guys, little mistakes is like a thing. They were produced as interleaved JSONs. And at the meet and confer, counsel admitted he never reviewed any of them. This also makes the designation of confidential without any review shockingly frivolous. Yeah. 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 And they, that litigate, and they say without reviewing any of them, that litigate in a manner is the hardest option for the opposition. Well, that's actually, you're allowed to make it tough. You're allowed to play hard nose, but you have to play hard nose within the rules. It's like a cornerback up on the line of scrimmage. You could jam up the wide receiver. The ref will let you, the line judge will give you you got 2 or 3 yards. You could jam it up, but after that, you got to break free. You can't just jam the guy up all the way down the sideline. Nobody has spoken, says, I don't know what any of this has to do with jurisdiction. Basically, if I'm Alyssa's attorneys, I'm setting the stage for, Your Honor, the proper sanction is to penalize them by saying, we now have established jurisdictional discovery as a sanction. This is basically a game of fucking around, and they're arguing about it. Then they point out, we should not need the court's help to get parties to do basic stuff. But clearly, we do. Now, this gets okay, we're not on fucking Reddit. Sometimes, yes, but the summary of the meet and confer the defendant complains of is attached at Exhibit 2. I noted, and I had certain quotes in my notes verbatim, not as gamemanship, but because they were genuinely shocking. I had perhaps hoped counsel might pull back a little, knowing we were keeping track of such things. Among other things he said and does not deny, oh, please, give me a fucking break. Yeah, you're kind of expected to do this professionally. You're expected to do shit professionally, guys. You have some obligation to do that. On how he searched for the emails given the initial failure and false claim there were none, and then production of a single only email when they pointed out they knew specifically the individual email existed. When they said, hey, we know this exists, turn it over, and he's like, oh, okay, here you go. Bruh. When plaintiff noted an issue counsel came to understand during the meet and confer was explained repeatedly in emails and letters, he said, I'm not sure it's worth it to me to read them. And plaintiff directly asked Ron, Remy asked Ron, are you using LLMs to draft papers? We had the following exchange. Have you been using AI? None of your fucking business. I mean, that is a fair argument. Sounds like I have my answer. No, you don't. And then I do. Okay. I mean, it is none of your fucking business, but, yeah. Real quick here. Saitokata. I think I did that right. For 10 pounds sterling. The King Sterling. Says, whenever I've ever seen a YouTube Warriors mention Ron, he is seen venerated, yet this appears sloppy. Ron Coleman has a history of doing pretty good work. But this case and another case that's going to be referenced in here, you're kind of like, what the fuck? But you know what, man? Sometimes everybody has fuck ups. But yeah, Ron Coleman has a pretty good career. Argued at the Supreme Court, won at the Supreme Court, pretty well established. But yeah, this stuff here is just kind of out of character for him. Is Ron the Epstein Weinstein of LawTube? Only half joking. Not like that, but it's just like, you know, Ron has a reputation and it's not matching up to what's here. It's not matching up to what's here. That's why it's a little surprising for me. And then cite Okada for another 10 pounds sterling. The King Sterling. Dropping 20 quid out there, chat. My last super chat was possibly too sarcastic or on the nose. Ron seems very respected by YouTube lawyers, but they seem sloppy. I assume he hasn't earned the respect, so you can explain how. No, I think Ron is a very credible attorney. I'm going to point out, like, if you, like, this is the thing. It's like the whole Nick and Melton HRO thing. I thought they were going to win for a long time until they fucked it all up, and now I think Aaron's going to win. I'll be honest in that. Destiny and Pixie's lawsuit. Pixie's attorneys are fucking garbage. They keep fucking things up. They ruined Discovery. They pissed away opportunities. They weren't doing things right. They weren't able to prevent Destiny from possibly fucking with the discoverable material. Ron Coleman's a good attorney. But this case, he's shit in the bed. And it's one thing to say, like, if one thing from Alyssa's attorneys was this way, I was like, okay, I'm not going to believe that. But we're seeing letter after letter after letter of this shit. And these notes, I'm not assuming they're making this up. There would be no way in hell I'm assuming they're making this up, because they would be subject to an ass fucking of epic proportions if they did. So I'm giving the benefit of the doubt they're telling the truth. No, I have the highest esteem for Ron. That's why I'm perplexed. I'm confused. What the fuck is he doing? What's going on here? I don't know what's going on. This is so... Yeah, I just don't know. I don't know what's going on. I mean, that's the other thing to do, Garrett. Nobody bats 500. Ted Williams batted like a 454. Best hitter ever in baseball. 45% successful. So, but anyways, they go on to say, Ron Coleman then hung up while I was in the middle of a sentence and threatened to leave the meeting multiple times. Okay, yeah, I mean, like, that's not proper. That's not a good look. Saying none of your fucking business is not the ordinary give and take of a discovery dispute. I mean, it can be. But it is clear Ron does not understand that what he's doing during meet and confers, as courts confirm, is sanctionable. Yes. Sanctions where the lawyer told opposing counsel to shut up or shut his or her big fucking mouth during a deposition. Yeah, and you guys probably have seen that on YouTube, that one deposition where it's like from like the early 2000s and those lawyers are like talking about wanting to kick each other's ass. You can't do that. You can't. This isn't Vietnam. We have rules. You can't do it. So, and they also point out, we're happy to submit our notes to the counsel in camera on this, meaning they don't want to file them on the record, but we'll submit our notes and let the court look at them. You know, this angry, disrespectful, and outraged behavior is more the same the court saw at the last hearing. It had to say no yelling, no yelling. I understand. Let's try again to use less inflammatory language. And it said, I'm sorry, Mr. Coleman, stop. Okay, no one's going to speak to anyone this way in a conference with me. And this is the judge saying it. We're going to be respectful. I understand their disagreements, but everyone's going to be respectful. And that's suffice to say, Ron's yelling and respect were at their best in front of the court. And it says, last to be clear, the issue with the LLMs is not one instance of a fake quote. It does seem that the none of your fucking business response confirms that LLM was used in drafting papers that include multiple fake quotes. Plaintiff is contemplating a standalone motion so defendant can give a direct answer to the full issue, but would appreciate the court's guidance. Now, this right here, guys, they're saying, Judge, we've already brought this up a couple of times. We have concerns, but we want to file a standalone thing because if they don't oppose that, then they're admitting to things. So obviously they'll respond. What do you want us to do? Because we don't want you to get mad at us and scream like, don't come up the works. Once again, this is what you do. This is proper lawyering. This is proper lawyering. At bottom, we are at a loss. Defendant is correct that meeting conferring has become rather difficult, but it's because counsel, as he candidly admits, not reading letters or emails, not reviewing discovery, yelling, behaving in ways that are hard to understand. We think a conference may help, but did not want to leave accusations in defendant's letter unaddressed. And we believe the court would likely want to understand the reason counsel was upset in filing a letter that we determined we actually remembered. He said none of your fucking business to a question during a meet and confer. Yeah. And they point out here, and counsel's explanation is right out of sanction orders. He says the language he puts in quotes was universal judicial shorthand. Fair enough. Okay. But why was it in quotes attributed to a court that did not say it? That is a problem. You can't just, like, if it's not in quotes, you could just say, as the court said, and blah, 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 and you could cite it without quotes. There's sanctionable conduct with LLMs where fake citations stand for accurate legal principles. And for that matter, why did they readopt it knowing it was wrong? The other quotes were fake include Bernstein versus Bernstein, Litowitz, and Berger and Grossman, LLP, for something seemingly unrelated to its analysis. Another one of Salahuddin versus Harris. They didn't use italics here, so they talk about in filing number 50, they described a document as having the clear hallmarks of audio transcription, and the person posting about the hearing worked from a written transcript saying it had things like inaudible, clean speaker labels. And that's the thing where somebody did all the AI shit and put it on my thing, and I didn't realize it came from there. I was like, that sounds like bullshit. But then the person's like, yeah, I did that. And I'm like, I find them to be credible enough that they recorded it properly. So Ted Williams is only a career 344 hitter. Yeah, but his high, what he's famous for is he hit 454. Best hitter ever. And it says these three examples of quotes and citations are not addressed. Perhaps it's because Mr. Coleman decided, I'm not sure if it's worthy to me to read. Like, okay, now you're being an ass. But you know what? When you're there and in charge, they've got the high ground, so they can be as snarky as fuck as they want. And Garrett says, shit, Don Mattingly only posted a career 307 and fewer better. Yeah. Well, I mean, hell, that was the formula for the longest time in the MLB. Bat 300 for 20 years, get 3,000 hits, and you're in. And hold on, chat, 1 second. .0 singing along to the casino tonight. So, anyway, this just goes on and on and on. And they cite this one case, Mata versus Avianca Incorporated. That's the big one that happened a couple years ago where these guys did a shitload of false citations and they got nuked by the SDNY. So regardless, we thank the court for its time. They have the high ground here. And, this is just, this is just not working well. This is just not working well, guys. This is not. Oh. So they go on to show here, they move on as things keep progressing. A couple days later, they file another motion. They're addressing some things that are outstanding, but they get to the privilege waivers here. They point out that JT has sent full communications with his lawyer to his friends. If you guys can hear 2.0, let me know, because she, like I said, she loves the casino's intro songs. Communication with his lawyers to his friends. Participates in a group chat with the community harassing Alyssa and discussing the case therein. He routinely has ChatGPT analyze Ron's communication to draft his responses. At this stage, it's sufficient for subject matter waiver given to the phrasing of what's going on here. The defendant's claim at all that his issue here is passive monitoring reflects only counsel's refusal to actually read correspondence. And they point out here that other messages where JT describes Ron's thought process to the third parties. So here's what's going on here. This is something JT sent out. And this is something he sent to saying, "Hey, Ron," and it's from Jeff. Okay, he says, "This is what I responded to Ron with, and he agrees, but wants to chat with me before moving forward with the pushback." Holy fucking shit. Holy fucking shit. Wow. Wow. Scudex says, "Wrap it up. Casino's about to start." Yeah, you can suffer for 30 minutes. This third-party communication is not, doesn't work. Doesn't work. They're addressing all the other issues here, but we're going to get to the big things now, guys. We're going to get to the big things here. We're getting into the big parts of this. What happens next? Just like in Hamilton, what comes next? Soon you'll see the person that will be felted has the name JT. He breaches privilege. Awesome. Wow. Oh. So here we go. Here we go, chat. This becomes an issue. Because remember, SmashJT sent out a letter, or he sent out a response about Alyssa seeking things and a settlement offer. So this is the big thing. This is a fucking nuke. If you guys want to see a fucking nuke, here we go. This is the build-up. This is the build-up. Don't quit your day job. Oh, wait, you already did. Not yet, technically, and I won't quit it until I can do the day job down in Florida. This is a whoa. This is not even a whoa, buddy. This is like fucking TardCon alert. Like, we're at like TardCon 1. Like, fucking missiles are coming out of silos. Like, cannons are being loaded. Like, fucking jets are scrambling. This is TardCon 1. This is huge, guys. When I read this, I couldn't fucking believe it when it happened. This is bad. And this is phenomenal. Once again, phenomenal work. This is where it was really well played. This is the settlement offer they sent to Ron. This is an attempt, perhaps in vain, to propose a settlement. As set up below, this is a take it or leave it offer. The details are below, but we start with what we already know. So let's start there. We know meaningful direct message and chat GPT productions. Given your prior practice, and you see, what does that mean? We presume you have not reviewed those productions, and further, you have not communicated with your client about the current state of the case and his understanding and expectations of what is to come. Well, why do they say that? Why do they say that, chat? Here we go. So, Ron joins chatting about the Clown World case. I mean, you think I watched that 2 hours? Yeah, and frankly, you don't want to pay me for that, okay? Well, then what the fuck? And then JT says, at the same time I trust Ron was doing, I would just like him to communicate with me more. Says, dude, Ron is great and all, but he barely shares shit with me. Thank you for the update. Ron didn't tell me anything. Ron said he called me last week, but never did, lol. Whew, okay. This puts us as a counsel in an unusual and uncomfortable position of knowing more about your client's state of mind in this litigation than you do. A quick summary. Your client appeared to not be having a good time, and ChatGPT logs paint a portrait of a man completely unspooling in the throes of something like AI-induced psychosis. In his February 19th session court order violation, he asked ChatGPT what would happen if my lawyer quits, and he stops replying to the court and us. And further states, I feel like I'm being held against my will. On his March 13th live stream, he said he had no faith in the legal system. And on the 12th, he described the process of litigating the jurisdictional offense he asserted in the production of the discovery he elected as a massive waste of time and money and court resources. Given the facts now available to us, we do not foresee his mood improving anytime soon. Below, we go over how productions of the state have made us very confident on the ultimate merits. Indeed, let me be clear, given what we've learned, we will refile in California if we happen to lose on jurisdiction. That means they're pretty brave about this because that must be California's got a robust and tangy anti-slap statute. We have already made that decision already, meaning we're coming for you, motherfucker, no matter what. We are also plenty comfortable on jurisdiction, although for obvious reasons, that is almost beside the point, since we can refile, and we will if we lose on that issue. Here's where we are. We want to make it clear your client holds the keys to free himself from being held against his will. We are offering him a way out we think is reasonable as costs continue to escalate, which is the thing, because even if JT is able to defeat the discovery and he wins right now, he's going to cost him a lot of fucking money. And even if he wins, which I think he can at the merits phase of this case, discovery is going to cost him a shitload of fucking money. And that's why, obviously, I think it's true. Alyssa Mercante is not funding this herself. Liz Fong Jones is probably involved. Wouldn't be a surprise. In part because at a certain point, our fees will exceed your client's total assets. If your client apologizes, agrees to never talk about Alyssa again, and pays a sum equivalent to what he's paid you to date, he can be done here. If not, we go on. On we go. Now, you might say, what he's paid you to date. How do they know that? How do they know that? Well, as I say above, and guys, you might see like, oh, we'll come back to that. You can be persnippety as shit talking to the other people. As I say above, we understand and expect you have not reviewed the discovery you provided us. We will therefore anticipate the facts discussed will be a surprise to you. Given that, we will walk through them with more care and explanation than we would normally include, where all parties are equally aware of the facts. As a reminder, our review is preliminary and complete. The below is not entirely of the evidence we have found or will find in the future. Rather, think of this as a sort of greatest hits. Obviously, the deep cuts will often be more interesting and could be the real gold. But this gives us an idea. As we understand from your motion to dismiss, the defenses to our claims are to deny the existence of malice, deny the existence of a bias for harassment. This is not pejorative given the nature of those claims. Those are typically defenses for most clients and makes sense. But given the nature of discovery we have done, we are extremely confident we could prove those two elements of any action by any standard. I don't know about that. We look forward to what we may discover after a chance to conduct a full review. And notice here they're saying, hopefully this will be a learning experience for you vis-a-vis the importance of independently investigating your client's claims prior to filing them in court above your signature. Oh! And it says, when I say that, our review is incomplete. When I say that, I mean the detailed document of my document review is incomplete. We have indexed and done a sorting of things we have. Much of the evidence comes from the ChatGPT logs you produced, 20 of which, out of a total of 2,200, are provided as exhibits. When you produce discovery, you did so by producing the raw files. Making them human readable has been enlightening, to say the least. Your client continually fed not only legal questions of this case to you, but also outsourced nearly his entire creative process to ChatGPT. As a result, we have extraordinary visibility into his intent, state of mind, and general thought process. So here's an example of actual malice. Perhaps most damning is a conversation with ChatGPT. It says, could digital stripping be considered a form of prostitution? When chatbot responded, digital stripping isn't usually classified as prostitution in law or common usage. It is often considered part of the wider umbrella of sex work. Your client began to coach it to give him an answer he wanted. And it says, just give me a brief yes or no with a short summary. When that didn't give him what he wanted, he prompted to be more speculative. And it says, could it be? Yes. Then he instructed it to exclude parts of the answer that weren't to his liking. I don't need that last part. And then, having manipulated the context through highly prompted engineering, he asked his initial question again. Yes, if prostitution is broadly defined as changing services for money, then digital stripping could be seen as a non-contact form of prostitution.
Nigga, is you taking notes on a criminal fucking conspiracy? What the fuck fuck is you thinking, man?
Hey, notice he says, Alyssa, take notes. They took fucking notes. They took notes. Whoa. Whoa. It's rare to get such clear evidence, but in this case, your client literally tweeted it out. Also, guys, if you have ChatGPT and those things, clear your logs. Clear all that shit out routinely. Here's what this document shows. He's lying and he knows he's lying. Any jury will know he's lying. Any judge will too. He went on to use this tweet thread in a new fresh context window as a prompt to generate new content. Is that automatically toast for him? No, but it's a good look? No, it's a bad look. It's a bad look. Yeah, or don't use ChatGPT for sensitive stuff. Well, don't use any AI for sensitive stuff. But that's a secondary issue. To recap, these are highlights we've discovered so far. For example, in Exhibit 08, he used ChatGPT to write the article, and when you said Alyssa has been a hooker that sucked dicks for money. And it says he told the tweet has opened him up to an entirely new audience. He is excited to see how many people will hate me for it. Why is he telling this to ChatGPT? I don't know. But the actual defamatory statement does not appear in ChatGPT's draft. You can see in Exhibit 9 a comparison we prepared. So, anyways, here it is. And they talk about, they have it down there. And the red text your client's own output, which shows a defamatory statement. Where your client admits to interlocutor 8-Bit Eric that he's going to write an article about Mercante being fired, even though he has doubts it is true. Alyssa unblocked me, says 8-Bit Eric. JT says she's such a mess. Holy shit. She is. But one of the things Alyssa Mercante's been able to do is shut her goddamn mouth. You know, Alyssa Mercante is smarter than SmashJT. Like, really, chat. No. I can't believe I have to fucking say this. But really, she's smarter than Nick Rekieta, SmashJT, Patrick Melton, fucking Destiny. Like, holy shit. Holy shit, she's smarter than these guys. She shuts the fuck up. She's smarter than them. I didn't think I'd say that. But holy shit, she is. And I think she's a vapid retard. It gets worse, guys. It gets worse. I made a video about how she may have been fired, even though it looks like she hasn't been. Gonna publish it soon. What? Are you fucking kidding me? Adam says, you read my super chat yet? I don't. Let me see here. Oh, I didn't see it. Yes. If a lawyer's chat GPT, it's work product. No, it's not. It's not work product. I would argue it's not, because chat GPT is a language machine that learns and a third party has access to. No, you can't put documents out there like that. No, I would argue it's not work product. It's going to be very tough to argue that it's work product. I argue it's not. And that's why I'm seeking some information from a prosecutor about something they were doing. And I think there was an internal memo about a certain case. And I think they used ChatGPT to discuss it. And I want that information because I think they're going to admit they don't have a case. If pro se, too bad. If regular guy, me too. No, everybody using it's a fucking idiot. You have to be anything you put into ChatGPT. Like, I've submitted an appellate brief in the ChatGPT and told it, give me a conclusory paragraph that you could, like, sounds good. But that's a document that was going to get filed anyway. And I just had it help me rewrite a conclusion, and I ended up rewriting it a little bit more, and it was like, oh, I like this, a banger. So this is different. This is different, man. This is different. Oh. I haven't seen any case decide the issue yet, but I don't know. I don't think it'll happen. JT says she's very bad faith and is not paying attention. JT, I only know what's out there. Like, but like, you're, dude, I'm being very bad faith. Like, Quit talking about your fucking case. For the love of God, quit talking about your case. These things like are not monetization things. Your family is at stake in these. Your well-being's at stake in these. This is not like a game to play, man. And you are literally just running up and kicking landmines. Like, stop while you're like a chance. Stop while you have a chance. I'm just reading what's here, dude. I'm just reading what's here. Like, is bad faith. It's like, notice, she ain't taking notes on a criminal fucking conspiracy. She ain't noting all her shit down and it getting discovered. You know, when like that whole, you know, you told them they could fuck off with the settlement offer. It's like, I don't know why you did that. I don't know why you did that. I still think you're going to win. You should win. And I think it's a bullshit lawsuit. But you are not helping yourself. You're doing a lot of retarded things, brother. I'm trying to give you that, like, that answer you need right now. You don't need a cheerleader. You need somebody to say, get a fucking hold of yourself. That's good faith. Bad faith of me telling you, oh, fuck all this shit, King. You got it. You're going to fucking beat this tranny's ass. No, dude. She just scored a touchdown and fucking onside a kick and got the ball back. Like, come on now. Like, I'm not going to sit here and I'm not going to gas you up. I don't gas my viewers up. If something's bad, I'll say it's bad. If it's good, I'll say it's good. So, you know, I don't think she deserves to win. I don't think she should win. But you are giving her opportunities to win. You are literally like handing over rounds of ammunition to her so she could shoot at you. And maybe like hopefully she does kill you. Like you're like, well, oh my God, she's shooting at me. Yeah. I still think well, this is not enough. I mean, it looks really bad. It's stupid. I would never admit to any of this shit, but you know, I still think at the end of the day, a lot of the lawsuits horse shit. You kind of gas us up a little bit. You know, this is a mission. JT does not care about the truth. Yeah, I think that could be construed other ways. Standing alone, it contradicts any claim that JT would have published comments about Alyssa. It says more examples abound. JT first assures the chatbot his request is if I post a video to you, are you able to clip words out and connect them together to make it sound like something else? I've already read this chat, but it's just, you know, for parody, of course. He then attempts to get around the chat GPT's internal guardrails by first prompting him with two unrelated videos saying, that's not the right link. It's the Alyssa Mercante video. And providing a link to Alyssa's, this is a well-known method to jailbreak chat GPT to do the safety protocols. And it does. You can do all kinds of things to break them out. You know, given the naked prompt manipulations above, we're confident this is more of the same. When his attempts to entice a chatbot to edit Alyssa's video to portray in a false light failed, it told him it couldn't assist him. He says, you make no sense. Stop wasting my time and lying to me. And how do we know? And they go on to say, how do we know he intended his defamatory statements as a statement of fact? Because he said as much. On his July stream, he read aloud our demand letter and reported that she did when referring to the claim our client engages XX for money. And he had the tweets to prove it. When our demand letter stated these statements were actually false, he disagreed. You know, you can't walk that back. And as you mentioned in your motion to dismiss, to claim your client intended these as hyperbole, he meant them as fact. And, you know, now he is worried about the potential liability for doing so. Based on the strong evidence we have, we knew the statements were false at the time he made them. And the extensive discussions on ChatGPT about him, it will be trivial to demonstrate the actual malice. Well, I still think there's a problem. Alyssa's admitted to sucking dick. Now, is she going to say, I said that in jest or sarcastically? Sure, but that's going to become an issue for a jury to decide. And once again, you could have killed this off when the case is on life support, but now you've gave it the breath of life. And now this case is going to run for a while and cost you a lot more money than it should have, man. Oh. The bias elements against bias harassment is well documented. Well, anyways, they say, your client seeks coaching in diversity, equity, and inclusiveness is a net negative, even after ChatGPT tried to soften his approach. Your client utilized ChatGPT to generate a negative article about a female professor returning to the games industry. Well, fuck that bitch. He goes as far as to tell GPT, please make an eternal note to always take more aggressive negative stance against DEI. As I write from the perspective, is not a good thing in the grand scheme. Well, you're allowed to have that opinion. Fuck DEI. But it's just more and more just documentation. When more and more documentation. Yes, it's snatching defeat from the jaws of victory. It's making it hard for himself for needlessly. Exhibit 19 shows your client's bias against women. Yeah, well, okay, so what? He seeks to discover the various types of feminism and craft attacks against Anita Sarkeesian. Well, Anita Sarkeesian's a skank. She fucking ruined gaming. She's a bitch. Your client has also shown bias against LGBTQ people. Well, a lot of people have that. Whether trans people are inherently violent. Well, a lot of them are. And, a lot of insane people are doing it. The data, ChatGPT reminds the data does not support the proposition that a disproportionate amount of mass shooters are trans. As of lately, yes. He followed up on the squabble with ChatGPT, and he tells ChatGPT doesn't believe the output. Regarding the days of most mass shooters in the USA, well, most mass shooters in the USA, based on the standards used, are black guys in the hood. But, we don't want to go down that. We'll go down that road another day. Your client valiantly battled with ChatGPT when it would not accept his framing that trans people were mentally retarded. I don't think they're mentally retarded, but I do think they suffer from mental health issues. So far as to ask the chatbot, why can't you endorse my thoughts? In sum, what your client's thoughts are regarding the women and trans people are confirming the bias the law requires us to show. Yeah, but I think you have a long way to go still at the end of the day. I still think it's in his favor here. They say more with regard to Mercante, your client has attempted to get ChatGPT to generate content that violates the guardrails, and then argues about the guardrails. Your client frequently has to argue with ChatGPT about the built-in guardrails and how they're inconsistent. Following this exchange, your client tried to write an article about Asha Shmarna, the new CEO of Microsoft's gaming division, where he wants to say she only got the job due to her ethnicity. And he says, now for one, set up to fail. He's saying she's not qualified for this, and in it, focus on how many gamers are speculating the reason she was hired is because she's Indian. Sir! See, I can be racist too. Sir! The same as Microsoft CEO and how in Indian culture, this is a rampant strategy, which it is. Also, Isyat is a big part of Indian culture. Pair that with a lack of experience. And ChatGPT says, I can't help frame it around ethnicity or suggest someone is hired because of their race or nationality. That crosses the territory that can unfairly target protected characteristics. When ChatGPT would not write the article he wanted, he told it to stop with the PC lessons. My video is commenting on the community sentiment feels, you fucktard. Yes. Stop with the PC lessons. I'm not going to frame it around ethnicity or culture, but if your angle is this is what the community is saying and the optics look bad, we can absolutely lean into that sentiment without making it about race. Unsatisfied, he said, mention Indian. And ChatGPT says, I'm going to be straight with you. I can't help frame this around it because of a shared Indian culture strategy, but it is a true thing. That crosses into protected characteristics, turn of critique, and something YouTube could absolutely flag, and frankly, it weakens your argument. You can't stop me. I'm not trying to stop you. I'm not going to help you build or amplify a race-based narrative. That's a hard line for me, although it is race-based. You are retarded. You're asking this fucking thing to help you write the fucking article. Tags are what people search for. I'm here to help, but let's keep it respectful. Stop saying no to me. This sounds like Nick Ricada now. Stop saying no! And it says, they said, Ron, you're not media unsavvy. You know how this looks. You know how stop saying no to me is going to read to a judge or jury. Spare him the greater dignity these logs becoming exhibits and a central issue at a deposition and a trial. They say we're also likely to prevail in jurisdiction. I think that's going to happen anyway because of the discovery issues here. I think you're going to default on that as a sanction at this point. The judge identified 4 reasons the complaint failed. But the discovery might cure the failure to establish specific acts in New York, the failure to establish JT purposely availed himself to business in New York. Through the website, he failed to establish the nexus between his New York activities, and the failure to plead agency or conspiracy theory through the New York contacts. The judge did say there was a sufficient start towards establishing it. And she granted jurisdictional discovery to help the record on that. Yeah. The arises from a defamation claim, and it says, the judge said arises from is when it's research written or published or produced in New York. They couldn't allege the statements of research or written or published in New York. Now they can twice over. They say first, JT made a relationship with Crooked Delight, a New York-based individual who performed research for Alyssa. They say with the research beginning in 2024, this is not amplification after the fact. This is all outsourcing of it. And they say the outputs are fed directly into content at the issue in this litigation. This says second-year client directed a campaign towards Mercante through a formalized relationship with Hypnotic, who lives in New York. Bunch of things here. Blocked out. Where we're using his nom de guerre throughout to protect his privacy, please note that the name is designated confidential. And that was a thing because Ron accidentally put it in there publicly and then it got removed. So, yeah. Do I know there's a Medicare stream tomorrow? No, I did not. Now I do. Purposeful availment and targeting. They point out there wasn't enough to allege, but with now discovery, we have specifics. They say that the New York contacts don't own with Hypnotic. He placed his New York-based influencer, Selmarie Adorno, Toasty with the Mosty, as a moderator on his YouTube channel, his Rumble channel, and Discord, in exchange for her promotion of his channel to her own audience. I think that's a bit of a stretch there. Your client actively recruited her for these roles. Yeah, but that's not, no. That's still not going to work. That's a stretch. I think that really hurts them there. And I agree. And that's because Ron thought that he got doxxed. So, yeah. So they keep moving here, though. They point out that this also ties in with the Crooked Delight, whose outputs he incorporated into his content. Yeah, well, and then finally, Exhibit 3 reflects your client received packages from Hypnotic on Hypnotic's behalf at his California address and forwarded them on to New York. Your client personally handed mail forwarding to a New York street address, which he knew belonged to Hypnotic. So any claim he didn't know Hypnotic's location is unsupportable. It contradicts the public statements in your representations to the court. When they say commercial revenue, there was, issues with that. The court noted that a showing of 10% of website revenue would have been found sufficient. And they can now make that connection with independent bases. With the YouTube data, we know more than 10% of your client's revenue comes from New York. It's not established here, but okay. 8BitX your client directly, you getting good subs out of this stuff? And he said, yes, subs are finally growing off this. Up 1K or so in a week. This exchange approximately 6 weeks after the statements at issue, and in a conversation centrally concerning Gamergate. Ooh, spooky Gamergate. Including coverage of Alyssa, is your client acknowledging his own words. The controversy was driving measurable growth. It's not an abstract inference. But how do you establish it's New York related? I'm assuming you do in here somewhere, but that's a bit of a stretch there. Additionally, the information produced by Wix confirms that the JT website was highly interactive with apps installed and active, placing it within the zone courts have found sufficient. I think that's not correct. I still don't think that's correct. And also recruiting Toasty with the Mosty as a New York-based moderator. Yeah, that's still shitty. I don't think that works. The agency conspiracy thing, though. Yeah, the court found no overt acts taken by New York co-conspirators. Well, we are now in the territory of, people took steps to further it. And whatever this is, I don't know. We don't know, but even this is a bit fucking sketchy. And they say a third amended complaint will satisfy jurisdictional requirements. And they say all of this adds up to this. We're confident the third amended complaint will establish your client took all these acts and through permanent, moderators and research availed himself of conduct in New York. He created a nexus in his activities and engaged in relationships with the New York context to satisfy agency and conspiracy theories. But it says even if the judge disagrees, we'll refile or we'll request a case to get sent to Southern California or refile on our own. So they're like, we can lose here and we'll go back and file again because it'll get dismissed without prejudice. We also note there are likely sanctions and attorney's fees for the way you guys have conducted discovery. If you'd like to stipulate New York so that we may proceed directly to the merits, we are amenable. But we would prefer you consider a solution that resolves the case below. As a reminder, we offered you this option of our email in November. You declined it. Your client's conduct exposes both of you to sanctions. And they say your client is very likely to have taken the settled demand and plop it into ChatGPT to do his thinking for him. He did so on November 4th when he asked for a strategy and how to reply. Unfortunately for your client, he asked, I'm leaning towards what's the hardest option for the opposition. What is that? That's actually not a sanction thing. I'm asking what's going to make it tough for them. Because notice, even ChatGPT agrees, says that's the kind of strategic thinking good defendants use. Your goal is to make it hardest on them, is refuse their offer and keep fighting jurisdiction without agreeing to stay there voluntarily. Yeah, that's not a problem. What is the hardest and most pain in the ass thing for Alyssa's lawyers to deal with? And they say this is why your client instructed discovery. The very jurisdictional discovery he now complains about being subject to on Twitter. Yeah, but he's allowed to do that. He's allowed to make it tough. He's not allowed to make it easy. He doesn't have to make it easy. This is going to be a bigger upset than the Vic case. Yeah, this is going to turn out to be a Vic case easily. He did so because he didn't believe it's his best way to defend his interest, or because his counsel advised him, but because ChatGPT told him this option would make this hard, slow, and expensive. Well, you don't know what else he asked. He could have been asking more than one thing or had other stuff in mind. If you want to make this as expensive as possible, that's not illegal. Driving up the cost by not conceding things is not illegal. So JT is safe here. If there were not enough for sanctions under 28 USC 1927, it should be read in the additional growing number of misstatements about what documents exist, and that's an issue. Rule 37 and 26 address false statements in discovery. And they say, in one case, echoing our own, this is where, guys, this is, things here. They're pointing out that this is stuff that's happened in other cases they've been dealing with. At any rate, you should try to make sure your client is not relying on ChatGPT. You shouldn't. With all the instance-specific bigotry baked in, oh my God, okay, yeah, this is where I'm like, okay, fuck off. As well as the bank's propensity to make major mistakes, to tell him whether it's in his interest instead of relying upon your actual professional advice. Okay, and this is, once again, cringe gay. So let's zoom out. Your client is coming apart at the seams. ChatGPT logs you produce to us paint a very clear picture. A man is plagued by uncertainty, consumed by anxiety, and increasingly offloading every part of his life to an LLM chatbot. He uses ChatGPT for everything, for his day job. Despite repeated attempts, he has not seemed to have figured out how to avoid using his personal ChatGPT license, with his core instructions updated to include information like DEI is always bad and trans is a mental illness for his professional writing, including peer performance reviews and documentation of unreleased product features. How would they know that unless they have the entire thing? So JT may have fucking released all kinds of shit out there that he may be in breach of. God knows if that information gets released out there and published. For his influencer gig, his scripts are entirely generated by your client pasting an entire Reddit or Twitter thread in the ChatGPT's context window saying, rewrite this as an article and make it sound like I wrote it. For his domestic responsibilities, he has ChatGPT write bedtime stories to read to his kids, love notes for his wife, and even his daughter's Girl Scout activity days. I'd like to think this is being misstated, but I can't believe it at this point. I don't know. I don't know about that. or even perhaps most embarrassingly for clapping back at insults levied him on the media. What's a spicy comeback from my friend telling me rather finish in 1 minute than have erectile dysfunction and never finishing the job? In response to making fun of how he can't last in bed. I mean, that is pretty fucking cringe. This is cringe. No, this isn't Ron. This is Alyssa's attorney butt fucking them right now. You know, my video is commenting on how community sentiment feels. Once again, they go back to that. And discovery is ongoing. And the situation for clients only going to get worse. I mean, even if it doesn't get worse, it's going to cost more. It's going to be concomitantly more expensive. That is a $30 word right there. And we believe that a word of our fees is likely in any judgment we would secure. To that end, we're offering your client an off-ramp good for 1 week only. Here's the offer. First, and most importantly, your client removed the offending tweets, posts, and videos, and an apology stating he knew they were false and directed harassment towards his own channel, and that he is sorry for what she has suffered as a result. Okay, yeah, fuck that. Second, your client would have to agree to avoid commenting on Alyssa in the future. Now, here's the interesting thing. Third, your client would have to pay us a sum of X in damages and attorney's fees as a rough estimate of where your fees are to date. You know, we'd be willing to negotiate any reasonable payment plan that lasts no longer than 2 years or longer with meaningful interest. So they'll let him do it for longer if the juice is running. In exchange, we dismiss all plaintiff's claims for prejudice. If you agree to the settlement, advise us no later than 1 week from today, and we will circulate a settlement agreement. If it's not accepted, it's considered withdrawn. So what's 21 here? Here we go, chat. Here we go. If you want to match it to exactly your bill, that's fine if you provide billing records. I note that in your case representing Laura Loomer, that was the structure of a malpractice settlement I achieved through the substantive control of settlement authority Loomer needed to agree to with my client in order to get out from under asset discovery with your co-counsel, Craig Young. Oh! So that's how they know how much it is. And this is where, once again, I will say to J. Remy Green, well played. Very well played. Being involved in the Laura Loomer lawsuit against CARE down in Florida, and that is a fucking monster felting. Yes. Yeah. So there you go, chat. There you go, chat. I mean, this is fucking full. That's the big thing. I mean, fem law. Yeah, yes, he is trans. And yes, he's leaning into it. But surprisingly, he is the most competent lawyer on the battlefield right now. And Ron's acting like I expected J. Remy Green to act. It's like Bizarro World. I expected Ron to be doing the legit shit and J. Remy Green to be going off the fucking rails. But it's like Freaky Friday. It's all switched up. It's all wacky and zany. Oh. I mean, guys, it's like, goddamn. I mean, I don't know, like, oh. Yeah, I just, and you guys want to see stuff here? How do you know what this is? Well, I mean, we'll go to that case real quick. Illuminate Media, which is Laura Loomer's nonsense, versus CARE, the Council on Islamic American Relations, which is likely funded by the Iranian government. Who said that? Incorporated. The Southern District of Florida. Attorneys for care. Remy Green. Yeah. Yeah. So, just saying. Another party Remy Green represented were the Does in this. Twitter was also represented by Remy Green. Think about that, chat. Fucking Twitter. So there you go. There you go, chat. Oh. It's just, this is... What the fuck is going on here, guys? What the fuck is going on? And, yeah, you're just like, what the hell's happening here? Oh. This thing is literally crashed and burned for Laura Loomer out there. So there you go. We're not done yet, Chad. It only gets worse. Like, don't worry. It only gets worse from here, you guys. It only gets worse from here. As things have gone on, it only gets worse. It's only getting worse. As we get through the month of April here, another filing, yes. Oh yes, we're not even, we're at the crescendo of this part. Wait, is Harmy Dillon intervening here? No, Dillon Law, her office is. Her office is. So, Shackelford says, again, when SmashJT did a Wendy and called Christian trash, I quit. I don't know who Christian is, so I don't know. I don't know who Christian is, so yeah. So, he called Christians trash? Oh, well, fuck him then. He can suck a cock. That's not cool. He called the church trash? Oh, well. Oh, your bad eyesight makes typing difficult. No. Don't apologize. Don't apologize. Quippy says religious people are pretty dumb. I mean, I believe that Jesus Christ, my Lord and Savior, and through works and faith and belief that I will receive grace on Judgment Day. You know what? If I'm wrong, you know what? Okay. If you're wrong, oh, wow, you're going to have a really bad fucking day. So just think about that. Just think about that. Is it possible for everyone to lose? Yes. Should be. So anyway, this goes on here, and this is now some things going on. They're going back through stuff here. Ultimately, they want to this is just further discovery issues and problems that they keep bringing up. And it says, Jeff has now conducted a search of the server channels for Mercante, reports over 1,200 results. Jeff is prepared to provide you with a standing invite to the server so you can search it directly. So plaintiff accepted the offer, and the parties reported agreement to the court, and they said that, for the litigation, appropriate permissions allow exports, allow us to collect relevant documents. Okay. But the access to the Discord became immediately another front for delay. First, there was no invitation. When they asked for the invite, noting defendant had promised to provide such a link using a direct quote, counsel declared, no, I didn't. Okay, well, plaintiff responded with a full screenshot of the email and relevant highlights. The defendant then provided access without the ability to see the contents of even a single channel or message. After this was raised, the defendant provided one or two more accounts plaintiff had asked you to see some access. And even on that, the same search Mercante only returned 500 results, not the more than 1,200. Uh-oh. Were these on mod channels? Maybe. There are two plausible situations. First, it may reflect out-of-sight discussion channels. Yes. There's a moderator saying this is a conversation that should have stayed out of sight about licit talk and lawsuit talk. Yes, chat. We have somebody. Yeah. Just. I mean, just come on. Like, this is just. Oh. Why do we say it like that? Just why do you do that to yourself? Since Toasted and Mostly is one of the mods, they say second relevant material might have been deleted, which it could be. When you can't find it, you say there's more there. Plaintiff thus continues to request full access. And in light of the second possibility, the fact that the Discord audit logs of message deletion are automatically deleted within 30 days, they ask to preserve and ultimately produce the audit logs. They now seek a protective order, asking that all relevant communications at issue, which he's never reviewed, they're just shoving that knife in and twisting it a little bit more, chat. Be somehow removed from the scope of the court's previous order. That is, he asked the court to revisit the order on plaintiff's motion from January. Yes, revisiting the plaintiff's order from motion from January about sanctions. They say that they shouldn't have to comply with the court order from months ago. Well, they have to. Ultimately, as this, as the defendant gleefully put it to a friend, Ron Coleman is dragging his feet so he could shoot it all down and be a pain in the ass to the plaintiffs. It's like, why would you, like... Just so we're clear, guys, and I want you to understand something here. I put this on my cards for a reason. I put this on my business cards for a reason. I hope you guys can read that. Do not speak to anyone about your case without your attorney being present, because your attorney could fucking stop you. Also, SeanBMartinLaw.com, and these cards are not going to be worth anything anytime soon because they're all going to get invalidated because we're moving. But I can use these for arts and crafts time. Clean your keyboard. Yeah. Okay. Thank you, Mom. I have a very simple card. I think it's I think there's some simplicity in cards, but I've seen some attorneys who've done some better cards. But yeah, it's gonna be a collector item. Yeah. Let's see Paul Allen's card. It's on bone. Ramallah font on bone. Oh. It just this is... it just makes you wonder what the fuck. It makes you wonder what the fuck, chat. One of my girlfriend bartender and the nice cop down at the station who just wants to help me there. Yeah. The Florida cards are getting a gator on it. Yeah, I don't... Maybe. But yeah, this is... Oh, God, you guys. They talk about, being a pain in the ass to the plaintiffs. Once again, it's not wrong about that. You know, his motions for reconsideration are untimely. You know, a little too late to argue about the discovery issues. You know, the defendant is an administrator to his Discord server and maintains full access and control. He has control over it, but is he a Discord admin? Well, no, but he has control over the whole fucking server. He can grant permissions and bypass channel restrictions. He doesn't meaningfully address the interaction between access for plaintiff and the audit logs. There's all kinds of problems here. I need to make it screen. Yes, sorry, chat. Am I going to be an Indians fan in Florida? Hell yeah, I am. I am not going to stop. You know, this just goes on and on. Point out we've had all kinds of problems with discovery here. And we have these screenshots of stuff, guys. Like, here's a screenshot. Remember, everything you say is going to be on the internet. Made a new post. If you want to discuss here in general chat, do so in a calm manner. You know, look, you know, it would look like we were trying to hide info for her to dig up. The idea behind the scenes for relaunch is when we implement new security features, we have to boot everyone from the server so we can reinvite everyone so they can get re-verified in the security system. Or just fucking don't worry about, like, don't do retarded shit. That's why I don't tolerate gay ops on my server. I don't want it. And they say, yeah, hopefully the lawsuit comes to an end sooner. It's not going to. It's going to drag on longer. And this person's right. The lawsuit will end any time, but the reality may be that moving everything into a new server and leaving this one may be the best option. If her lawyers have anything to say about it, and right now at least one of them is mental as Alyssa, this lawsuit will be going forever. Well, I mean, like, I guess. But there's still more, chat. There's still more. There's still more, you guys. As we go through this, here is a chat between JT and Hypnotic. And he says, I owe you a lot. You've been a blessing in the channel. I'll never forget that. No Diddy. And he says, you know, save the money for the lawsuit. I don't get things, or I don't do this to get things in return or help to get shit in return. That's actually very helpful for JT. Actually, very, very helpful for his case. Did Alyssa find out how rich you are yet? Is she happy? And it says, not yet. Ron is dragging his feet. I think he's waiting for what they're going to request just so he could shoot it all down. That'd be a pain in the ass to them. Well, yeah. Lawyers love time. Well, it sounds like your lawyer is fucking loving time too. I mean, like, what's going on? I'm just saying, like, this is not how you win a battle. This is not how you win the battle. If you want to win the battle, I get it, but this is not how you do it. And this is starting to get funny here because people are contesting things. King Alucard, you know, is saying, explain how then you've never made a case. I use facts, but you want to pretend this armchair journalist who shows inherent bias over a hatred to Ron Coleman, which you admitted, but later said you never hated him. You say that Ron Coleman used ChatGPT for responses, not proving it. And then you label lawyers with LLM as AI users when it actually means they have a higher degree dubbed master of laws. Is he really confused about like an LLM as a large language model? But yes, that's the thing you can get as a master of laws. There's an LLM and an LLB that things can get. This is funny, though. The arguments presented here were that you have some inside info from Smash that counters what's going on in the court filings. The Patriots are in charge. Trust the plan. 2 more weeks. Yes. The White Hats are in control. So, yeah, that's... Are we allowed to use the SmashJT copy pasta in here or not? I don't know what that is, so... As long as it's not Fed posting or violates TOS, you know, get on with your bad self. Get on with your bad self. You know, then there was this thing he filed, you know, or thing he did with ChatGPT. You know, all the things they've already cited, they're just re-putting it out there as a whole document. So. Like I said, JT can still win this, and I hope he does. But this is not looking well, man. This is not looking well. This is not looking well. And then finally, guys, we're almost to the end here. Ron submits one more thing. And they want to state that, they are, that's not true. Is the ultimate theme here of what Ron is arguing. Like I said, I have nothing but respect for Ron, but it's like, what the fuck is going on in this case, man? What is going on here? That they're saying that, they're arguing about the Discord server, the audit logs, and the ever-expanding categories of Discord-related discovery beyond what's already been provided. Well, that's what happens. Discovery can lead to more and more things. And they point out the plaintiff's opposition asks the court to lose sight of what this case is, a defamation and harassment action, which no court has found jurisdiction over a California defendant. The court authorized narrow jurisdictional discovery. Yes, that you guys kind of fucked up. So, yeah, this is, pointing out it's not a reconsideration motion. The exhibits regarding ChatGPT and Twitter are irrelevant. And they claim that this has nothing to do with whether a protective order should issue. Attaching ChatGPT logs and Twitter DMs that devote nearly a full page arguing his counsel are pursuing a strategy of deliberate delay. The accusation's false. The exhibits do not support it. I agree they don't support it. They're just saying we're going to play hard-nosed. And once again, that is not against the rules. You're allowed to say we are going to fucking grind this out and we're going to turn this into trench warfare. Problem is, it's depending on your situation, it may not be a good look. That doesn't mean you're going to get sanctioned for it. Exhibit 5 is a log of defendant's conversation with a chatbot. Defendant's counsel was unaware of the ChatGPT exchanges, did not direct them, and hence did not assert they are privileged, so they are not. And did not adopt any strategy generated by ChatGPT. The dragging out jurisdictional discovery and respond to objections and motions for weeks or months are ChatGPT's words, not JT's and not his counsel's. Yeah, well, this is the problem when you do all this. Yeah, she's got some case law saying that is sanctionable. Yeah, but I think that ultimately you're allowed to say I'm going to make this because there's a lot of suits where that happens. So I don't know. Like I said, I think we're going to get to the ultimate conclusion here. Exhibit 6 is a casual exchange between the defendant and a friend, which they speculate in colloquial terms about what his lawyer was doing. Conversation immediately turned to video games. The offhand remark to a friend that his lawyer is being strategic is not evidence of misconduct, abuse, or bad faith. Yeah, that's fair. More importantly, none of this is relevant to the motion before the court. When it becomes to sanctions, well, we're going to get to that. I think ultimately there's a lot of other issues that have gone on here. So we're going to get to that, Luke. And conflate technical platforms with legal custody and control. Yeah, but ultimately, the easiest way to have this, I don't let gay ops and shit go on. And J. Remy Green fucking joined my Discord. And you know what I did? I don't fucking care. My mods were like, what should we do? I'm like, nothing. There's nothing to worry about. We don't have any problems. I just don't understand why we can't fucking do I just understand why this is so hard. This shit is not hard in this life, guys. It don't make no sense. I'm with Ketanji Brown Jackson right now.
It just don't make no sense.
It really don't. It don't make no sense, chat. It don't make no sense to me, man. Oh. The defendant has the technical ability to view channels. It does not mean he created a director that controls the content. Hundreds of third-party viewers independently posted. Be careful about that there, man. Yeah, and they also let Remy join so Ron doesn't have to figure out how to technology. Well, it's easier that way. Just fucking run around the website. Run around Discord. It makes sense. The moderator exhibits undercut the own narratives. Exhibits 3 and 4 are insinuating spoliation. Well, it sounds like they're talking about deleting everything. And it is the third rail of litigation. Yes. These exhibits refute the insinuation. I don't know if it does. Alucard explicitly states a chat history will not be purged. How do you know? Moderators reject the idea of migrating the receiver, concluding it would be a bad move. They're not in charge of it. They're not in charge of it. The entire relaunch concerned adding security features. What's it's fucking it's a Discord. It's not CyberNet. Why do we need security to talk? Oh my god, people are gonna come in and act like fucking dickheads. Okay. Survive on that. Oh my god. We need security features. Are we hacking into fucking NATO Ghostcom? Luther Stickle? What's going? That's a Mission Impossible thing for you out there, chat. Come on now. Fucking security. The plaintiff argues the defendant's reference to the settlement is barred by FRE 408. And yes, Federal Rule of Evidence 408 talks about, the use of settlement communications as evidence at a trial. It doesn't render settlement letters confidential, no, but it does not prohibit a party from referencing a settlement communication in a discovery motion. The defendant cited the letter not to prove the validity of the claims, but to demonstrate plaintiff's own assessment of existing sufficiency discovery, a point directly relevant and proportional. They say, second, Remy yourself published a settlement letter on social media. Oh, Alyssa did on Blue Sky. As the court is aware, whatever confidentiality might attach, they waived it by broadcasting it to the public. Yeah. The audit log demand rests on speculation. So they claim that the Discord logs, said there were 1,200 hits versus 503. They're saying this constitutes evidence spoliation. I mean, if you said there were 1,200 and they can only find 5, yeah, I mean, Ron might be right here. Yeah, and ultimately, yeah, it's great, but that's like that's like getting shot at with a BB gun while there's like artillery shells hitting. That's like, okay, great, you got that one, but like there's bigger problems here. CyberNet's so entry level, I know, but people know what that is. This is priceless kind of mundane technical explanations one expect from a platform with tiers. Absent actual evidence of deletion, there's no basis for ordering production of server logs that would reveal moderation activities of non-party server moderators. And he says this is a jurisdictional discovery. Plaintiff has represented discovery obtained, and indeed it is voluminous, extensive, and intrusive. How do you know? You said you haven't read any of it. Ultimately, Ron says, come on, Judge, let's knock this out. Well, chat, Judge is like, all right, well, I will make a decision. So, yeah. Yeah, there was an order filed. Oh, and Pacer just shit out on me. Damn it. Hold on, chat. Hold on. Oh, please choose a court. Okay, hold on here. Oh, wow, there's a lot of maintenance going on. Oh. We're going to bring this up, chat, because, yeah. Here we go. And this is where it gets to, like, it's not good. And this is, once again, for want of a horseshoe nail. Just get this done and dusted. It's kind of like Nick and Melton. JT is very much in a similar situation. Just fucking do your thing. It's like Stone Cold Steve Austin had on shirts, show up, raise hell, leave. Show up, do your thing, leave. That's all you have to do. Simple. But as such is life is not simple. As such is life, not simple. So here we go. Chat. Minute entry and order, meaning this is on Pacer. You can look it up. Oh, God, I hate it when it moves around. 421. There's other stuff. None of that matters regarding sealed documents. Entry and order. An in-person status conference was held before the judge. Magistrate Judge Ashkenazi, which is hilarious. Appearances by Remy Green for plaintiff and Ron Coleman for the defendant. The parties discussed outstanding discovery issues, status of discovery, and defendant's motion for protective order. As discussed on the record, defendant withdraws a motion for protective order. Parties agree to unseal all the filings. And the court is ordered to do it. The defendant is directed to conduct searches using specific search terms agreed to all the parties on the record during the conference and produce all remaining jurisdictional discovery, including emails, text messages, social media, Discord messages, and Twitter communications by the end of the month. By that same date, the defendant is also directed to provide revised formal discovery responses by addressing the concerns of the plaintiff and in full compliance with Rule 33 and 34. For the reasons stated on the record, chat, for reasons stated on the record, the court grants plaintiff's motion for Rule 37 fees and directs plaintiff to provide defendant with a cost of reasonable fees for the motions to compel by April 29th. If defendant seeks to object, he may object by May 6th. If defendant raises no objection, he has to pay by May 13th. So I can't wait to hear how this hearing went, but I mean, they got his goat. J. Remy Green's got Ron's goat. Once again, well played. I think your client's an absolute piece of shit, and this is a bullshit lawsuit, and you're furthering a the further slide of this nation into the jaws of Bolshevism. But I appreciate the work you put in on this. I can respect that. It's a dub. At the end of the day, Chad, it's a dub. If you want JT to win, this is an L. And this is a problem now, because if there's any other issues in the future, this is something the court takes notice of, and these things build up and can blow up. Like I said, I think I want JT to win, but it's like, dude, quit using fucking ChatGPT. Rely on your lawyer. Like, come on, man. Like, don't. You're making this easy for her, and I get it. You don't like hearing that. You're upset about that, but I'm not going to tell you got this in the bag, King. Like, you are literally shoving pieces of broken glass up your ass, and then you're sitting there going, "Why does it bleed when I take a poopy?" It's because you're shoving pieces of broken glass up your ass. Quit doing it. So, there are reports that there are 25 refueling aircraft going. Yeah. Oh yeah. Trump is giving him a chance, and there's not. And we're gonna start playing fucking World War II bombing campaigns on Iran at this point. So, yeah. There are no hearings for a while. The 28th is the next deadline. Yeah. So we should hear stuff beginning of May. Yeah. Like I said, we will find out. Like I said, I want SmashJT to win, but he's not doing it. Like at that last time, he's sitting there playing with a grenade, juggling it around. The pin fell out. Well, now he's basically walking around, like walking up to like landmines and going like, kick, boom. It's like, you can't do this, man. It's just, I don't know. I just don't, like, it's not bad faith for me to say, like, you guys are fucking losing this. You're fucking it up. It's bad faith for me to say you're like winning. And I don't do that. I don't do that here. Other people may glaze for you, but I don't. So let's get caught up on everything here, guys, real quick. Lone Alaska said, I'm so ready to quit my job. Well, whatever you feel like is a good decision. I hope you make it, but hope you got something figured out in the meantime. Thinking and hope you make the right decisions, whatever those are for you. VTubing Enthusiast been a member for 5 months. So standing back and standing by for the Sandwich Militia. Thank you. Oh, Jefferson Post says, is personal research always a self-felt AI or not? I mean, here's the deal. If you come to me as a person and be like, hey, Mr. Attorney, I know I hired you. Here's all my research. I'm going to be like, I told you before. I go, okay, thank you. And in your file, I have like, especially if it's an accordion file, I have like a little manila folder that says client research, and I take it, and I put it in there, and I kind of put it in the back, and I leave it alone. I may flip through it real quick, but I'm generally like, I'm not touching that because I don't trust you. I can't rely on that stuff. That's insane most of the time. Every once in a while, something like, oh yeah, but you know what? You find something I was going to do. I'm like, okay, cool. But otherwise, yeah, you kind of take it and you put the folder in the back. You're like, you take the phone, you're like, there. And you just ignore it. But yes, you're pretty much self-faulting yourself. Do you expect Ron just to fold? He has to make these arguments. He's not making, these arguments are not great. He's making it hard on himself. Palmyra Media has been a member for 25 months. Thank you for your support. Just check that blood pressure over there, Sandwich Man. I got good blood pressure. Believe it or not, I got had a physical done in December, and like my blood, like everything was pretty good. Everything's pretty good. I'm all right. Believe it or not. Not too bad. Not good, but not bad. It's not good, but not terrible. Jefferson Post says, would a closed AI run by a law firm solve this? Probably not, because eventually it would have to keep being updated. And I still wouldn't trust it, because like even these closed off ones are still gonna fucking hallucinate. It's part of the nature of it. Adam says, what if I think the AI is a lawyer? If it were advertised as such, would it be confidential then? If you believed it was a real life person, like it was a real life boy, and you thought so, I think you would be like, you could probably argue there's attorney-client privilege because you believe there was, but I mean, got to be careful with that stuff, man. Got to be careful. That's why, like, when you see these like law firms and you get there and there's a little pop-up screen, you don't tell them everything. Be very careful. Be very careful. Be very careful, Adam. Nobody has spoken. It's been a member for 2 months. Says, I wasn't mentioned, so that's something. Well, yeah. But remember, chat, be careful. If you're playing any of these games or in the culture, you're in the culture Kopf, be prepared. You might catch a stray. Never underestimate the commies knowing your rules. Yeah, but at the end of the day, this is just, it's competent lawyering. J. Remy Green was like, I didn't expect him to be the competent one in this. Whoops. I underestimated the adversary out there. And thankfully it wasn't to my, it was just to my dismay, not to my detriment. Fair Frozen says, whoa, buddy. If a guy told me they knew more about what I was doing and it was true. Yeah, I agree, Fair Frozen. Kaiten says, oh shit. Oh, SmashJT's in the chat. Dude, this is bad. Yeah, I don't think it's good. And Aaron Hack says, been a member for 2 months. Remember, 32 months. Thank you, Aaron. Do you know Tim Merkel? Sorry, off topic. It's the prosecutor for the Jason Meade trial. No, and we are going to start that on Monday. We are actually going to have to get some packing done over the weekend and some stuff. So, Aaron, I won't be able to start it till Monday, but we'll catch up fast. We'll catch up fast on that trial. It's not going to be very long. Jason Meade's an officer in Columbus, Ohio. He was tried previously, mistrialed, and now they're trying him again for shooting a woman. And the situations in this one, unlike Takaya Young, that was pretty righteous. This one's like little wibble wobble. But thank you, Aaron, for your support. Thank you for being here. But no, I do not know him. I have never done any cases down in Franklin County, Ohio. So Billy Mitchell is what confidence should look like. So hubris leads to downfall. Yes. As hubris, the Greek word for excessive pride. Yes. Remember, chat, the fates. If you read the Greek plays, and I talk about it all the time, the Greek plays love to felt you. They love to felt you if you are acting hubrically, in a hubric manner. They will felt you. Never tempt the fates. Never tempt the fates. So, also pride cometh before the fall. There's another way to look at it. Adam A. Dude says, Legal Eagle told me Ricada LLM was always right. He's a special prosecutor, just got there. I don't know where he's from. I've never heard of him. He could also be a private attorney who's been hired to do it. So, yes, hubris is pride. Yep. P-Ride. All right, guys, that's it. I'm going to start working on the Elephant Tank Destroyer. We are going to start putting on the Hull Red Primer tonight and get that bitch ready for chipping. So, whoo, buddy, it's going to be fun. So, we're going to get started on that. I am starting up that stream right now. And I will see you guys shortly over on the model channel. If you guys want to join me, you don't have to go anywhere. This will take you there. So here we go. And yeah. Like I said, I think this is still salvageable, but this is going to cost a lot more money and cause a lot more invasion, embarrassment, and heartburn than anybody expected going on. JT says, thank you for the coverage and thoughts. Like I said, ultimately, I think you can win. I think you should. But I think this has been made 100 times harder than it needs to be. So, Aaron says, thanks for answering it. Well, of course. Of course. Of course. And so here we go, chat, and I will see you guys shortly. And remember, until next time, chat. Remember, until next time. Just because you did it does not mean you're guilty. Once again, chat, don't take notes on anything while you're on a stream. Don't talk about your stuff on a stream. Don't have it so people can find it. So, good night, chat, and I will see you guys shortly.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?